Good afternoon, everyone. My name is Dana Voglitis. I'm the Assistant Director of the Office of Technology Development here at FAU. If you're not familiar with our office, we manage intellectual property created by FAU faculty, staff, and students. We provide impartial consultation on various legal protection and commercialization strategies, and collaborate with outside attorneys and consultants to offer additional resources. Some of the resources we offer to the FAU community for free include evaluation of new intellectual property, securing patent, copyright, and trademark protection, developing marketing and commercialization strategies, negotiating option, license, and related agreements, assisting faculty, staff, and student startup companies, and providing outreach and education services such as this webinar. If you'd like more information about our office, you can contact us at techdevelop@fau.edu. You can search Office of Technology Development on the FAU website or follow us on social media. Our handle is @FAU Tech Develop. Now, our webinar today is titled Legal Issues in University Research, where we'll touch on emerging issues in intellectual property that affect university researchers, such as navigating the patent application process, conducting prior art searches, and international patent protection. And our speakers today come from the law firm of Caesar Ribas, located in Philadelphia, Pennsylvania, and they serve as outside intellectual property counsel for our office. We have three speakers from the firm today. First is David Tenner, the managing partner of Caesar Ribas, a law firm which has specialized in intellectual property law since its founding in 1926. David has a master's and bachelor's degrees in chemistry and over 25 years of experience as an intellectual property law attorney. His practice comprises all aspects of intellectual property law, including analyzing, procuring, challenging, and enforcing patents, trademarks and copyrights on behalf of individuals, small businesses, research institutions, and multinational corporations. Our second speaker is Saval Desai, who's a registered patent attorney with experience in chemical and consumer products fields. Saval is a graduate of Rutgers Law School and received her undergraduate degree in biological anthropology from Drew University. Her practice comprises all aspects of intellectual property law, including patent, trademark, and copyright prosecution, litigation, and counseling. And our third speaker is Allison White, who's a registered patent attorney with a background in chemistry, biology, and the creative arts, who handles patent matters in the biological, chemical, and medical fields, as well as matters relating to copyrights and trademarks. She engages in both prosecution and litigation practice. She is a graduate of Villanova University's Charles Widger School of Law and received her undergraduate degree in nonfiction writing with minors in chemistry and political science at the University of Pittsburgh. So before we get started, I just want to mention that if anyone has any questions for our speakers throughout the presentation or at the end, you can submit those by using the Q&A feature at the bottom of your Zoom screen. Please do not use the chat feature as that has been disabled. Please submit any questions through the Q&A feature. And with that, I will turn it over to David to start the presentation.
Thank you, Dana. Thank you for inviting us to make this presentation today. We appreciate the opportunity to speak with you and your audience remotely and look forward to visiting there again soon. So for the next slide, please. These are the topics, as Dana mentioned, that we're going to be covering today. Starting off, well, the overarching concept is navigating the patent application process. In looking at the patent application process, we will be discussing tips for conducting prior art searches, and finally, international and foreign patent protection. Next slide, please. So before we get started on that path, I thought it would be a good idea to discuss what a patent is and what a patent isn't very briefly. So one definition of a U.S. patent is a monopoly granted to the patentee by the U.S. federal government. In exchange for giving the government a full disclosure of your invention, you're entitled to that limited monopoly. The patentee is granted the right to exclude others from practicing the invention. That right is limited to the U.S. and its territories. However, there are exceptions to that general rule. For example, importation into the U.S. of an unpatented product produced outside the U.S. by a patented process can be infringement. Patent protection, back one slide, please. Patent protection outside the US is available. We'll be discussing that later, but before a US-based invention is pursued outside the US, there's a requirement to get a foreign filing license so that the government has an opportunity to see whether there is any national security issues with it. In the process of filing for a patent application, the USPTO will provide that license fairly quickly in the process, usually within 6 months. So that's if an invention is created in the US, it's best if there's going to be filing outside the US to file in the US first. Next slide, please. Okay, so this slide is directed to disabusing you of the notion. It's a pretty common misconception about patents. And so a patent does not provide the patentee with the right to practice the invention. Another patent may dominate your patent. So these two Venn diagrams are directed to illustrating that visually. So the blue area of the Venn diagrams is the public domain, what's free to the public, and the gray area are the areas that relate to two different patents, patent A and patent B. In the top diagram, there is no overlap between the two patents, so that's not an issue for either. They're just adjacent. In the bottom diagram, as you can see, B is completely encompassed by A, and so for the patentee, the owner of patent B, to practice the invention, they require a license from the owner of patent A. Also, the owner of patent A cannot practice their invention within that area of patent B. So what typically can occur is there's a cross license between the two of them, or alternatively, the owner of patent B could wait, because typically it may be the case that it's an improvement, and so they may wait until patent A expires, and then they'll have free reign in that area of the circle of the Venn diagram B. And so they wait until the expiration of the patent. The next slide, please, which relates to patent terms. The term of protection for a US utility patent, and that's mainly what we're going to talk about today, is usually 20 years from the earliest effective filing date. There are a couple of exceptions that enable you to get extensions, one of which is pretty common. If the USPTO has unduly delayed the issuance of the patent, they have complicated rules for calculating an extension of time on your patent. So it could be 20 years plus some amount of time. An alternative is available for inventions that were delayed for FDA approval. You can apply for an extension of time based on that delay. Next slide, please. So this is an overview of navigating the patent application process. And we're going to start at the upper left where the invention is, and that's, so you create an invention, and what do you do then? Well, if you're affiliated with FAU, you're disclosing the invention to FAU. That's the next step. And from there, FAU and/or its outside counsel will then evaluate the invention for a variety of things that we'll discuss soon. And from there, if the evaluation suggests that you should proceed further down the road, you have two options, one of which is to the right, which is filing provisional application, and the other of which is going directly to filing a non-provisional application. And Savo, I believe, will address the differences later, but as you can see, there's two options. It gets kind of complicated at the bottom because you can pretty much go in a variety of directions from the initial filing. So if you go to the right, you're at the filing of a provisional application, and then within 12 months, you have to file either a non-provisional based on the provisional, or I should say, an international application or foreign applications within that year. And so there, as I said, there's a lot of arrows back and forth. For example, you could just file what's called a PCT application, and we'll talk about that later. And from there, you go back into the US. So that's why the arrow goes to the left from the bottom right. Next slide, please. I'm going to touch on some of the issues that I talked about last year when we were down there in last January, just very briefly. The disclosure of the invention, if you're with FAU, you're expected to disclose the invention to FAU. The prompt compliance with duties of disclosure and the prevention of undesirable disclosures are critical to developing and protecting IP rights. So your failure to promptly comply with the duties of disclosure can result in patent invalidation. You have duties, we have duties, whoever's filing the application, you have to comply with for the USPTO. And so that's what you have to tell them about. And on the flip side is untimely disclosures to the public can result in a loss of IP rights as well. Next slide, please. Pursuant to the IP policy of FAU, university personnel are required to promptly disclose all inventions to FAU. Your invention disclosure form prompts you for information necessary to evaluate the patentability, evaluate the licensing potential, prepare a patent application, and comply with disclosure duties owed to the USPTO. Next slide, please. A patent application, earlier on I said that a patent is I might not have said it as a contract, but in a sense it's thought of in some sense as a contract between you and the government, where in exchange for you giving the government a full disclosure of your invention, you get a monopoly for a limited amount of time. So by that theory, it makes sense that if you don't tell the government completely about your invention, you haven't upheld your end of the bargain and you should not be entitled to a patent. So that the bottom bullet points on this slide relate to the requirement that you provide a full description that's sufficiently detailed to enable a person of ordinary skill in the field to practice the invention with no more than routine experimentation. So Florida Atlantic inventors, it would be helpful in addition to making sure that that's the case. If you can identify utilities of the invention, it might help to attract or identify licensees. Next slide, please. Okay, some factors to consider in the evaluation of the invention. Is it worth patenting? Who owns the rights in the invention? Under US law, it's presumed that the inventor or inventors own the invention absent an agreement otherwise, or operation of law. In other words, there's some law that says based on how you created it and who you worked for, it might be owned by who you worked for. Joint inventors each own an undivided interest in the invention, absent an agreement to the contrary. Will the invention be practiced by the owner? Even if the owner is not going to practice it, will the patent prevent others from competing with the owner? So there is some value sometimes in just blocking others from competing with your existing technology. You're preventing new technology, but you're happy with your existing technology and you prevent the market from competing. Will the invention be licensed to others? Will the invention be better protected as a trade secret? A trade secret is essentially what it sounds like. So it's information that's of commercial value that's kept confidential to a business or organization. And so sometimes it's better to protect it that way than to try to obtain a patent. Factors to consider in that evaluation include whether the invention is difficult to reverse engineer. If it's going to take forever to reverse engineer an invention, you sometimes can be better off with a trade secret. Not exactly the category I'm thinking of, but you know, the secret recipe for Coca-Cola or for Kentucky Fried Chicken, they're not patented, never were. So they keep it a secret. It's not been reverse engineered. And it is those are trade secrets. The other factor to consider is whether the invention will have a long or short lifetime in the marketplace. So if the invention is only going to be commercially valuable for 2 years, it doesn't pay to file for a patent, because a patent can take 1 to 2 years under good conditions to obtain. And so before you get the patent, you have little value left. The question of patentability of an invention for a utility patent comes down to 3 requirements. The first of which is the subject matter must be patent eligible. That's become kind of a difficult situation lately because of some issues in the courts, but let me just touch on real quickly what the factors are. So the claimed invention has to be directed to a new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement of those. Secondly, the claimed invention, and this is where it becomes difficult to follow, even in the courts, it's not as predictable as it should be. The claimed invention must not be directed to a judicial exception unless the claim as a whole includes additional limitations amounting to significantly more than the exception. Okay, examples of exceptions, judicial exceptions to what otherwise might be patentable, are abstract ideas, laws of nature, and natural phenomena. Secondly, the second factor for patentability that's going to be evaluated for a utility patent is novelty. Novelty in a patent examination context is typically a patent examiner will find a single prior art reference, a single document, for example, a patent earlier than yours that teaches everything about your invention in that one reference. That would be a lack of novelty or being anticipated. The reference is considered an anticipating reference. Thirdly, and finally, is non-obviousness. Even if the invention is not exactly like what's been done before, would it have been obvious to a person of ordinary skill in the art at the time you filed the application? And typically that plays out in examination where an examiner will find a primary reference that has a lot of what you do, but it's missing a few elements, or one element at least, and we'll find a secondary reference to combine with the primary reference and say it would have been obvious to modify the first or primary reference with the secondary reference to get your invention. And that's how obviousness generally plays out. Next slide, please. And I believe at this point I'm handing it off to Sabal.
Yes, thanks, David. Hi, everyone. My name is Saval, and I'm the second speaker for today. I'd like to begin my portion of the presentation by talking about prior art. So prior art is any evidence that the invention is already known. And examples of prior art include, but aren't limited to, paper and electronic publications, like patents, public patent applications, which are not granted patents, but they're published during the pendency of the application for public inspection, and scientific journal articles. And it also includes oral presentations and posters presented at scientific meetings. These disclosures can be in the US or elsewhere, so really anywhere in the world, and they can be in any language. Next slide, please. Okay. Prior art is found through various prior art searches. And a prior art search is a search of various databases to determine if the invention has been previously described in any other references. And these references describing the invention or even components of the invention are referred to as prior art. So the next major question is, why are prior art searches important? They can help determine whether an invention is patentable before prosecution expenses are incurred. So it's useful to conduct a prior art search soon after an inventive concept is formed, just to determine whether the invention is already disclosed before more funds are spent on research and development, so that you're not pursuing a patent on something that's already out there, which you can't get. And so the primary goal for prior art searches is to identify at least one anticipating reference, which is one single reference that teaches every aspect or all the features of the invention in question. Now, this obviously isn't something that can always be found. So the secondary goal is to identify references that, when they're combined with other references, teach all the features of the invention. We use searching strategies for prior art searches, such as keyword searching, patent classification searching, and below is a link to a website that is that includes the classifications in like a long list. Forward-backward searching, which is identifying references in a certain patent, published patent or references, and identifying references that cite your reference after it has been published as either a patent or a published application. Also AI searching, which can be done in databases as common as Google, just by typing in a search term like something like such and such, which will use AI to generate results. And so the publicly available places where we go to do prior art searches are, for example, the USPTO website, which the downside is, unfortunately, that patents and published patent applications are in separate databases. So it can end up being kind of tedious to run searches twice. So there's also eSpaceNet, which I'm not sure if I'm pronouncing that right, but it is the EPO site. It's a worldwide patent and published application search. And this database is really awesome because it'll show you published applications in different countries and has a record of the some prosecution as well. And there's also Google, which is not confidential, but Google Patents and Google Scholars are two really good places for patents and scientific publication searches. Next slide, please. So my next topic is provisional applications, which I think David touched on briefly earlier. So just for some more detail, a provisional application is a U.S. national application filed in the USPTO. It establishes a priority date, which is the earliest filing date within a family of patents. It's good to have an earlier filing date because our patent system is a first to file system. Meaning that anything either filed or disclosed after the filing date may not be used as a reference against the application. And any prior art, so anything such as patents or publications before that date, can be used as a reference against the application. A provisional patent application is not substantively examined by the USPTO. And when you file one, you can use patent pending for up to 12 months. Next slide, please. So a provisional application is not required, but is recommended in specific situations, such as where filing is necessary on short notice. So let's say we have to file on short notice because the one-year date of a first disclosure is coming up. So since a provisional application doesn't have as many formality requirements, it's good just as something that we can get on file. It's also good in situations where you want to have something on file and then have more research and development of the invention in question. So the thing to remember for that one is the earlier filing date benefit does not extend to any matter that's added later on and that's not supported by the original disclosure in the provisional. So a provisional application, also just a quick note, does not diminish the 20-year term if a patent is eventually granted. Next slide, please. So what is required in a provisional application? So the main things is a specification, which contains a written description of the invention, at least one drawing if it's necessary to understand the invention, a filing fee, which is $300 for large entities and $150 for small entities, the name and address of each inventor, and the identification of any US government agency that has a property interest in the application. Next slide. Yes, so what is not required in a provisional application? Claims. Claims are actually a huge part of the non-provisional applications, and they are numbered paragraphs at the end of an application. They define what invention is being claimed as the property of the applicant. We typically recommend filing with claims. We also don't need an oath or declaration by the inventor or an information disclosure statement, an IDS, which is a submission of relevant background information that an applicant discloses to the USPTO during patent prosecution. Yes, okay, so my next topic is non-provisional applications. So this is the patent application that everyone thinks of when they think of a patent application. It is a utility patent application that is substantively examined for patentability by the USPTO. And this is the one that may be issued as a patent if all the requirements for patentability are met. It must be filed within 12 months of the provisional application filing date, if a provisional was filed, to preserve the benefit of the provisional application filing date. And inventions with the support of the US government, they have to be filed within 10 months of the provisional filing date instead of 12. So in a non-provisional application, content from an earlier provisional application can be supplemented with additional information. But again, it's important to remember that any claims or subject matter not supported by the original provisional disclosure are not entitled to the earlier filing date of the provisional application. So the next topic is the anatomy of a non-provisional utility application. There's 4 main parts, which is the specification, the drawings, the claims, and the abstract. A specification is a written description of the invention and the manner and process of making and using the invention. And one of the USPTO requirements for the specification is that it must be clear, full, concise, and in exact terms to enable any person skilled in the art or science to which the invention pertains to make and use the same. The next part is the claims. So these are the parts, the claims is the part of the application that undergo the most vigorous examination. And it's typically the part of the application where the applicant and the examiner go back and forth to sort of narrow down and define as best as possible. They appear at the end of the patent, and they define the scope of patent protection. So patents typically include many different claims of different scope and in different forms, such as product claims, process claims, method claims, etc. Each claim is a single sentence, and there's different types of claims. Independent claims and dependent claims. Dependent claims are those that depend from other claims as a shorthand means for incorporating all the limitations from the earlier claim. And independent claims do not depend from any other claims. And they usually tend to be a base claim that sort of encompasses the broadest representation of the invention. There are extra claim frees in certain situations, such as if there are more than 20 total claims, more than 3 independent claims, and if there are multiple dependent claims, which are dependent claims which refer back in the alternative to more than one preceding independent or dependent claim. So claims are written in a very specific format. Here we have just a brief example showing the 3 parts of the claim, which are the preamble, the transitional phase, and the body of the claim. I won't get into too much about the specific language used, but I did want to show you an example. And the transitional phase is particularly important in deciding the scope of the claim and what exactly is included and not included in that claim. Next slide, please. So there's also drawings, which are figures, photographs, drawings, graphs, and schematics that illustrate example embodiments of the invention. They're described in the specification, and it's very important to make sure that drawings are clear and easy to read, so they're not blurry, there's no weird dark lines through it, and usually drawings are in black and white, although in some instances they can be in color if it's necessary. So we just have to, in those instances, we just have to provide like a petition to the USPTO to show why the drawings need to be in color. So typically they end up being black and white. And the other part is the abstract, which I'm sure you're all familiar with since scientific papers also have them. It's a single paragraph, 150 words or less, and it avoids use of plain language such as comprising and said. I think that's the end of my portion of the presentation. So I'd like to pass it on to Allison.
Thanks, Saval. So moving on to our next section here, we'll get a chance to talk about the patent prosecution timeline. And this section is really about the logistics of what happens and the steps that you take once you bring your idea to a professional. And we'll go over how long each stage of the journey takes and just some things to expect along the way. So first, we will start off with how long will this timeline actually take? The average utility or plant application takes approximately 25 months from filing to a final decision on patentability, so a notice of allowance or final rejection, barring any appeals of that final rejection or unusual circumstances. Design applications run on a slightly shorter timeline, and those take about 18 months. So this is just a rough estimate of what to expect. But if you need to expedite the process, you can also pay extra fees to enter Track 1 prioritized examination, which has a goal on giving you a final decision on patentability within 12 months of Track 1 status being granted. And moving on to our next slide, you'll see our timeline graphic here, and we'll talk about the actual timeline, which has 5 major steps that we will discuss in more detail. So first, you'll likely work with a patent attorney or agent. You'll assist in the drafting process. You'll file the application. The application will be examined at the USPTO. And finally, you will get a final decision of patentability, which will result hopefully in a notice of allowance. Next slide, please. So once you have your idea, you will usually fill out a disclosure form, either if you're working for a law firm or your place of employment may have their own. And as David discussed earlier, FAU has their own disclosure form, which contains important information that patent professionals need to know. So some of these things are if the invention had been publicly disclosed before, if the invention received any federal funding, any problems that the invention is proposing to solve, and just general information about how to make and use the invention that's important to know when drafting. Next slide, please. So moving into our timeline again, we'll move to the drafting stage, which is actually where you're writing the patent specification and claims. Next slide. So one thing you may ask yourself is who drafts the application? So usually a patent professional drafts at the very least the final version, just because there are rules that the USPTO sets forth that determines very specific wording that should be used. So for example, when Saville was discussing transitional phrases earlier, the phrase you use matters in a claim because that can determine how broad or narrow your claim is. So how much the patent professional drafts is ultimately dependent on the amount of information they're given. If an inventor already has an initial draft of what could be a specification, such as an article they wrote about the invention or very detailed notes, this can help assure that all of the essential aspects of the invention are making it into the patent application. It also saves time and money because it's less time the patent professional needs to spend drafting from scratch. However, if a patent professional is approached with an idea that's fully formed but doesn't have a lot of documentation yet, in those cases, the patent professional may do the majority of the drafting with a lot of back and forth with the inventor to assure that the description of the invention is accurate. So ultimately, the decision works itself out based on how much material the inventor has written and the budget. Next slide, please. So one of the things any professional you are working with should be able to do is ensure that the application is meeting the requirements under Section 112, which the number of the statute, not important to remember, but it's focusing on whether the invention is adequately disclosed in the application. So the requirements for this are the written description requirement and the enablement requirement. And while these requirements ultimately have to be met in the final draft of the application, it's good to know these going forward because you will have more awareness of the amount of information or documentation you'll need to give a patent professional to ensure that your patent application sufficiently discloses the invention. Next slide, please. So we will discuss written description first. So the actual requirement is that the patent specification must, quote, describe the claimed invention in sufficient detail that one skilled in the art can reasonably conclude that the inventor had possession of the claimed invention. So what does that actually mean? It means that the patent application must describe enough to show that the inventor fully understood the invention, and it has to disclose enough of the invention's essential elements so that someone in what we call the skill of the art or the relevant technical field could look at the application and later issued patent and recreate that invention if they were given a license or after the patent's expiration. Next slide, please. So next we'll get to the enablement requirement, and this means that the specification of the application has to enable others to make and use the invention. And when we say enable others, we mean that ordinary person of skill in the art, so someone in the same technical field. So for example, if it's a pharmaceutical application, it should enable someone with a pharmacy degree or advanced chemistry degree to be able to create the compound or perform the method. Next slide, please. So ultimately, as you can see, the inventor and the information the inventor is providing is an incredibly important part of the drafting process. And often drafting will require multiple communications between the inventor and the patent professional, which can range from quick calls or emails to clarify a concept to actually submitting final drafts of the application for the inventor's review. The process is highly collaborative, and this is a good thing because the inventor knows the invention best. They can help assure that the application is capturing all of the essential elements of the invention, and the patent professional can also assure that not only disclosure requirements are met, but that the application is drafted as broadly as possible to cover any potential variations in technology that could appear later. Next slide. So next we get to the filing stage on our timeline, and this section will spend mostly talking about what happens when you file, and most importantly, how long you have to file after certain steps are taken. Next slide, please. So the USPTO operates under a first to file system, which means if two inventors independently invent the same apparatus, the one with the earliest effective filing date wins. So an example of this is if inventor A invents a machine that's completely novel and it's patentable, and inventor B independently, without knowing about inventor A, invents the same machine. Under the old laws, the outcome might have been different. It would have mattered who had invented first. However, under a first to file system, if inventor A files today and inventor B filed anytime before that, say a year ago, unfortunately for inventor A, they are not going to get the patent because inventor A's machine is what we call anticipated by inventor B's application. So inventor B, assuming this machine is completely novel, will receive the patent. So therefore, the sooner you file, the better. If you have an idea that's fully formed and developed, it's best not to sit on it. So now we will talk about one thing that comes up, especially in the research context, is using provisional applications, which we discussed earlier. So while the provisional application holds your filing dates and can give you more time to refine the invention, it's important to know that a 1-year clock starts ticking the moment that you file. So all non-provisional applications should be filed within a year of the filing of their corresponding provisional. So excluding the fact that January 1st is a federal holiday, this is just a very simple example. If you file a provisional on January 1st, 2020, the deadline to file the non-provisional is then January 1st, 2021. Next slide, please. So before you file, one thing to think about is this application based off of another application? And it's important to discuss this with any patent professional because you may be able to claim priority to an earlier filed application, like a provisional application, or even what's called a parent application, which you can think of as like a predecessor to the application being filed, or even an application filed in a foreign country. If you can do this, this means the new application can take the filing date of the earliest application in its continuous lineage, provided all of the filing deadlines were met. So as we said before, the earlier your filing date, the better, because less prior art can be cited against you. What happens after you file is not prior art that will not be cited against your application. An important note though, if the application does add new matter, which we had touched upon earlier, the new information will get its own filing date. So as we said before, new matter, if we could go back to the previous slide really quick. New matter is information that isn't supported by the earlier application. So if you disclose in a first application about drug class A and the child application discusses drug class A and Z, the information pertaining to drug class A would get the original filing date and the information pertaining to drug class Z would get the more recent filing date. Next slide, please. So here's a table of common filing deadlines. We've already talked about filing a non-provisional within a year of filing a provisional, but other deadlines to think about: if your US non-provisional is claiming priority to a PCT application, which David will discuss later, you'll need to file that within 30 months of the PCT's filing date to claim priority to it. If it's claiming priority to a foreign application, so say it's a patent you filed in Canada, you have a year to file in the US if it is to claim priority to that application, if it is a utility application, and if it's a design patent application, you have 6 months to file in the US. Also, if you're filing a continuation, a divisional, a continuation in part, which are applications that are based off of currently pending applications, you have to file after the filing date of the parent application, so the application it's based off of, but before a patent is granted on that parent application. So for this one, a patent professional can help you keep track of this deadline, especially if they are aware that you are thinking about filing a child application off of that parent. Next slide, please. So there's certain information any patent professional would need to know to fill out the forms required for filing your application with the USPTO. And it's important that whoever you're working with is aware of all of the inventor's names, addresses, and contact information. And also if the invention is being assigned to another, because then it can be recorded that that assignee can practice the invention. If you're employed by FAU, FAU is likely the assignee listed when you file. Also, you should disclose any articles or patents you relied on. that informs your invention. There's an obligation to disclose relevant prior art, so you should disclose these sources to your patent professional. And finally, you'll need to sign an inventor's oath or declaration, which basically would state that you as an inventor are the true inventor of that invention. Next slide, please. So next we get to the examination stage where the USPTO actually evaluates the application. Next slide. And once the application is filed, the USPTO will assign an examiner with a technical background in the field of the invention. So the USPTO has multiple departments, mechanical departments, chemical departments, among many others. And the examiner will be from one of those departments and trained in the technical area of the application. The examiner ultimately decides whether the invention is patentable and if the application has any deficiencies. If there is a deficiency, applicants are notified through what is called an office action, and applicants have 6 months to respond to these. But if you're working with a patent professional, they will likely be the ones to respond, but will present you with their proposed arguments so you can assure that everything stated about the invention is factually correct. Next slide, please. So why would you receive an office action? And sometimes it's just a formalities issue. So sometimes there could be a restriction requirement issued. And this is issued when the examiner finds that there's actually more than one invention in the application. So in that case, you would have to elect which invention that you are prosecuting, and you may file a divisional so that each invention becomes its own application. There can also be specification objections. So if a description is missing for one of the drawings or figures or charts. So that's why it's also important to make sure that any professional that you're working with receives adequate disclosure on what the figures are and what they mean. There could also be objections to the claims, and ultimately patent professionals evaluate claim format, but this is just more about formatting. And then there can be drawing objections. So if the only drawings that you provide are blurry or have faint lines or are convoluted, they can be hard to read, and you could get an office action for that. So this just shows the importance of providing clear drawings, especially if you are providing photographs and you do not want to submit color photographs. You have to think about how that translates into black and white. Sometimes sketches and diagrams can be easier to read, but it's often important to think about how will my graph or photograph translate once it's in the application. Next slide, please. So there are also substantive issues that could cause you to receive an office action. And receiving office actions are very common. And if you do receive one, it's often because the examiner is asserting that the invention is not novel, it's not new, or it's obvious. So for example, one reason you could receive an office action is if the subject matter of the invention is not patentable. So as we said earlier, abstract ideas are not patentable. And sometimes with software applications, it's common to have to argue that your invention isn't an abstract idea. Or if it's a natural phenomenon, no one invented that, so it's not patentable. The invention could also be cited as anticipated by another piece of prior art, which means that the invention isn't new or novel because it's already been disclosed. So then the applicant, through a patent professional, would argue how their invention differs from the prior art. The invention can also receive a rejection for being obvious, and it's up to the applicant through their professional to show that the invention is not obvious in response. So if an ordinary person in the technical field would know to put certain components together to create that invention, an examiner may assert that the invention is obvious. And you can argue around this by showing many different factors, which include but aren't limited to that the prior art actually led others to believe that the invention wasn't possible or wasn't practical, or that you received unexpected results during experimentation. And finally, there can be issues with written description or enablement, which we discussed earlier. Next slide, please. So office actions can be final or non-final. And in a non-final office action, you can modify your application based on the examiner's recommendations. You can argue why your invention is patentable and submit evidence to support your arguments. Or you can request further examination. One thing to note, if the examiner issues the same refusal twice, more often than not, that non-final office action will then become final. Next slide, please. So if it does become final, the applicant has a couple options with how to respond. The applicant can request an interview with the examiner, they can submit an after final amendment, they can file a request for continued examination, they can file a continuation application, or they can appeal to the Patent Trial and Appeal Board, known as the PTAB, and we'll discuss that in detail. Next slide, please. So if you request an interview with the examiner, you can use this as an opportunity to convince the examiner to reconsider. This interview could just be with the attorney or the agent, but the inventor can also attend. At the interview, you can discuss what the examiner's issues are with the application, why your invention is patentable, or any recommendations that the examiner has for you. Next slide, please. So if you submit an after final amendment, this means you are amending the application in a way that puts it in condition for allowance. So patent professionals will often determine the form of the amendment, but will collaborate with the inventor on the substance of the amendment. Next slide, please. So perhaps the application requires more than one amendment or more arguments to place it in condition for allowance, in which case you may want to submit a request for continued examination. And this is often filed in response to a final office action. Next slide, please. You can also file a continuation application, and this allows you to file the same application again, but you can vary the scope of the claims. So the disclosure is the same, but the claims can vary in scope. You just can't add completely new matter that is not supported by the application, as we discussed before, because then that new matter gets a different filing date. This basically restarts the examination process. Next slide, please. And then you can appeal to the PTAB as well. So to do that, a patent attorney could file a notice of appeal and a brief, which basically explains the issues that the examiner has brought and cited against your application and argues why the invention is patentable. You can also request an oral hearing. You don't have to, but it is an option. And the examiner has an opportunity to respond to the brief. Then the applicant has one more opportunity to reply to the examiner with a reply brief, and the PTAB will then issue a written decision on patentability. Next slide, please. So ultimately, after a final rejection, the options for a response may depend on the applicant's budget, their timeline, the monetary importance of the invention, and that can help you decide whether to keep examining that application or not. Next slide, please. And finally, we get to the light at the end of the tunnel, a final decision on patentability, which hopefully would result in a notice of allowance. Next slide, please. So if after examination and any arguments and amendments are submitted to the examiner, the application is deemed in condition for allowance, the applicant will receive what's called a notice of allowability, meaning they're going to get a patent. The applicant then has 3 months to pay the required fees, and then thereafter, there are maintenance fees that have to be paid every few years, and it's important to keep up with that to make sure you don't lose your patent rights. So this is all a broad overview of the timeline a patent goes through, but with that being said, I'm going to pass things along to David, who will be discussing filing PCT and international applications.
Thanks, Allison. So as you can see, we are at the lower right quadrant of the chart showing the flow of potential flow of navigating the application process. We're going to now talk about filing PCT and/or international or foreign applications. Although this is coming at the end of what Allison just described, it doesn't necessarily come at the end of, and it generally does not come at the end of U.S. prosecution, which takes longer than the year in which you generally have to file the international application. Next slide, please. Foreign patents. So each country has its own set of patent laws and regulations. There is no such thing as an international patent. Patents are granted on a country-by-country basis, although certain regional patents are available, for example, in Europe. Next slide, please. Claiming priority was possibly covered a bit earlier, but the point of it is that foreign applications filed within 1 year of a US application, and we're just talking about it from the US perspective at this point, since that's generally what all of you would be interested in. So foreign applications filed within 1 year of your original US application can claim the benefit of that US filing date. The 1 year deadline for foreign filing can be extended an additional 18 months to 30 months from your original filing date by filing an international application under the Patent Cooperation Treaty, which is the PCT. Most all countries in the world are participants in the PCT. Two significant countries that are not are Taiwan and Argentina, as you can see from the next slide, which is the next slide, please, which shows most of the globe, most of the world is shaded, and those are the countries that participate in the PCT. Next slide, please. This is a timeline of the PCT application process. Since we're running a little short on time, we're going to be hitting on all these things, but as you can see, you file 12 months later, you file your original application at 0 months, and then the PCT is due at 12 months. There's an international search report at 16 months. There's a publication at 18 months. There's an optional process at 22 months and 28 months. We'll discuss in a minute or two. And then finally, you enter the national phase, which is where you file in the countries that are members of the PCT. Next slide, please. So filing, the international application of a US applicant is filed with the USPTO or WIPO, which is the World Intellectual Property Organization. English is one of the accepted languages. And even if you file in the USPTO, the US Patent Office, you have the option of selecting other searching authorities, international searching authorities, or ISAs. So among those are the EPO, which is the European, Canadian, the Australian, the Japanese, South Korean, there's others. And the costs of the application vary based on the country that you pick to do the ISA report. Some of those costs will come back. If you pick the US or the EPO, it's generally more expensive, but they refund some of that if you ultimately enter the national phase. Sorry, so we're now on the slide about international search. Approximately 4 months after you file the PCT, the ISA that you selected will produce a written opinion regarding the patentability of the invention and cite references that it found, published patents and scientific literature, typically. Next slide, please. About 18 months or more after the original filing date, there will be publication of the international publication. If there has been no priority filed, it's 18 months from the international filing date. You can file a PCT as your first application. Next slide, please. There are basically four options for responding to the written opinion. The first of which is to submit an informal comment to the written opinion. It's not going to be published. It'll be passed along in the file to all the national offices who can take it into your comment into consideration when and if you enter those national offices. Second choice is to file an amendment under Article 19 for the claims only. This will be published, and so because of that, it's a very short time limit on responding to the written opinion because the publication occurs very soon after the written opinion is supposed to be issued. Third choice is to file an amendment under Article 34, which will not be published. So there's more time to put this together, and the amendments will result in further examination, and what's called an international preliminary examination report will be issued. So it's an opportunity to argue with the examiner about why you believe their position is incorrect, or to submit amendments that change your position so that you get a favorable report. The final option is to do nothing at all in response to the written opinion. You're not required to do anything. So if you do nothing, that opinion will be passed along when you go to the next step, which is the next slide, the national phase. So it's at this point that your international phase transitions to a national phase. This occurs at 30 months in many countries. There are significant countries that give you 31 months to do it. Europe, I believe, is one that gives you 31 months. In any event, that's the point at which huge costs are involved if you're filing in a lot of countries. If you're filing in a dozen countries or more, you're talking over $100,000 most likely in costs. So one of the advantages in filing a PCT is you have an additional 18 months to figure out where am I going to file, and is it worth filing anywhere? You'll get an opinion from the international office, and so that will help you decide whether it's worth pursuing. And what else I should say about the PCT written opinion and the IPER, which is the document that you get if you request further examination. They're influential, but they're non-binding on national examinations. So, you know, you don't necessarily have to address them because it may not be persuasive in a particular office, but for the most part, the offices tend to go along with it. It's just they're not bound to do so. A favorable report from the international office can be used to request expedited examination under what's called the patent prosecution highway, where they kind of rely on the examination that was done internationally and take a look at it, and you may get a quick examination and allowance in a given country. The US and many of the major countries participate in that PPH program. Next slide, please. Oh, that's it. Well, thank you very much for your attention. We're happy to answer any questions you might have.
Great. Thank you so much, David, Allison, and Savil. You've managed to include a lot of information on patent law in a presentation in a very short period of time, so I'm sure people will have questions. So I'm just going to give a moment or two. If anyone would like to ask the panelists a question, you can submit it using the Q&A feature at the bottom of your screen. And in the meantime, while we wait and see if any questions come in, I know a question my office gets a lot has to do with how much does it cost to file a patent application and all the different variations, provisional, non-provisional, filing in different countries, what are those costs like? And at FAU, although my office pays for the costs of any patent applications, inventors often want to know how much of an investment is required to obtain a patent. So if one or a few of you could speak to that kind of generally, I think that's something that people would be interested to know.
I'll speak to that. So the official fees range, and I don't think we've mentioned throughout the official fees. So a provisional application filing for official fees is about $150 for a small entity, and a small entity is an organization that's 500 or fewer employees and has no obligation to assign any rights or share any rights with a large entity. Or it's a your organization is a large organization, but it's a nonprofit. So they also come under the definition of small entity for the most part. So that's the official fees for a provisional. Non-provisional, I believe the number is currently about $785 for a small entity to file, and double that roughly for a large entity. PCT filings are several $1,000s for the official fees. In terms of our fees, they vary depending on the complexity. We generally charge hourly. I'm going to talk not just about us, but about in general. My experience is from surveys from patent lawyers, because I'd prefer not to talk about our specific charges. That a simple invention that's a provisional application that doesn't that's a full disclosure and not just simply putting a cover sheet on something and filing it. It can run, depending what firm you're talking about, it can run from $3,000 up to $7,000 if it's basically uncomplicated. And if you're talking about a non-provisional application where it's being written from scratch, not based on an earlier one, you can, and it's medium complexity in a variety of different fields. I think the range is more like the $7,000 to $12,000. But if you're talking about larger firms, will be more in the range that goes up in the 10 to 20,000, particularly if it's as it gets more complicated and it's high tech biotechnology or electronics that's complicated. Yeah, the prices can go up.
Great. Well, thank you for that. I don't see any questions yet, but if anyone has any questions after the fact for any of our panelists today, you can feel free to email them to me. Again, our email address is techdevelop@fau.edu, and I can pass those along to the panelists. So again, thank you all for participating, and thank you to the panelists for your time and preparation. And we'll see you all soon.
Thank you.
Thank you.
Take care.